Hey there, it's me, Tracy B, the Divorce Solutionist. I am here for Thick of It Thursday, as I am every Thursday at 4 p.m. Eastern Standard Time. I am coming to you from home. Anyway, I decided to. So I think most of you know that I get a lot of my scenarios, fact patterns, uh, circumstances, situations, topics from my audience. And my audience is anybody who listens to me is considered part of my audience, whether they are in one of my groups or they follow my page or they're on my email list or they're just in another group and they listen to my advice, which I do a lot. That's my audience. And so I take a lot of the questions that they ask or the topics that they bring up, I use those to, address them here in Thick of It Thursday. Although last week I decided to add tea time. So I'm going to do that occasionally. This week I'm going to go back to my old format, which is choosing a topic or a couple of related topics that I see people have been asking about lately. And so this week is legal custody, joint legal custody, not joint physical, not shared, not 50-50, joint legal custody. And I'm talking about that because in theory, a lot of us knows what that is, but in practice, that may be a whole nother story. And so I've been seeing a lot of people come in with questions asking if a specific incident or circumstance or situation or exchange, whatever, if it falls under the realm of joint legal custody or not. And so I wanted to take some time today to put out some different scenarios to let you so that you can get a clearer idea of what joint legal custody is and what it is not. So, joint legal custody, first of all, is usually granted by the court, and each state, I'm sorry, ice cream truck is coming. I have my door open because it's hot here. But joint legal custody is usually when the parents, both parents, have joint decision making. And that means that physical custody can be sole, it could be shared, joint, but joint legal custody is something entirely different than physical custody. Legal custody means both parents have say in certain things, certain areas, certain topics, certain issues surrounding their child or children. And so it usually refers to their education, their medical, extracurricular activities, and sometimes um, religion. It depends. Every state defines joint legal custody differently. Some of them don't even actually specify what joint legal custody is, so the parties are free to do that. But for the most part, joint legal custody is when both parents have the right to have some input in making decisions regarding their kids when it comes to which school they're going to go to, or if they're going to do tutoring as far as was concerned. If they, one parent wants the child or the children to attend therapy, if there's joint legal custody, both parents have to agree to that. Or if there's a medical procedure that the doctor or the medical professionals are suggesting, both parties have a say in that, and so on, things like that. The problem is, though, what when parents are dealing with something and they don't know if it's considered joint legal custody or if it falls under that guise. That's one problem. Another problem is if the parties don't agree and there's nothing in the parenting agreement or parenting plan that says who gets the final say. And I see that a lot. I see that's very, very, very common. I see when people come into anywhere where I am and I see the question asked, a lot of times they're wondering, well, what happens when there's a stalemate? What happens when they don't agree? What are we supposed to do? Do we go back to court? Does one trump the other because one may have physical custody, or does one trump the other because they have sole custody? And the answer is no, it doesn't work that way. Now, if the parties agree to allow the other person or the residential or the sole custody parent to be the final decision maker, that's fine. If they want to decide which areas they do that in, that's fine too. If they decide to use a neutral third party as the decision maker, that's fine too. Now, these are all things that the parents can resort to when there is no agreement. I mean, when the agreement doesn't specify who's supposed to be the deal breaker, who's supposed to be the final decision maker. However, just because you have an agreement doesn't mean that you can't work some things out on your own, that you can't agree to who is going to be the final decision maker in scenarios like that on your own. You don't have to run to court for that. In fact, most judges would like to see parents, co-parents without court intervention most of the time, right? In some states, you have the assistance or the opportunity to use a parent coordinator where, there's a neutral third party who you could just go to for an issue like that, and that's it. Or I forgot what they call them in some states. They call them, there's parent coordinators, and there's something like a co-parenting specialist or co-parenting there's so many ways to term that, but the bottom line is sometimes they just serve as a neutral party to help the parents make a decision or to come to a resolution regarding an issue. The whole purpose is to avoid going to court, because as you know and I know, going to court every time there's a disagreement can be very, very expensive, can be more sorry. It can create more conflict when there's already enough conflict. It can be counterintuitive because sometimes the issue needs a resolution today and you don't get a court date until next month. So sometimes running to court is not always the answer. It's not always feasible. So those are the options. You can, if there's no provision that specifically says who is the final decision maker, you could do one of those things. You can decide amongst yourselves. You can employ the help or the assistance of someone in your jurisdiction who would serve as as a neutral party to help you hash out or help make the decision or be the decision maker. There's so many realms. Or you can go to court. You can go to court, and which is not a bad idea. You can go to court and get the parenting agreement or the parenting plan modified so that you're not dealing with this issue every single time there's a stalemate or there's an impasse. Okay, you can do that too. Again, that just use discernment when whatever method or whichever path you decide to choose to go down. You want to use for me, everything is about doing a cost benefit analysis. If you spend $2,500 to get this resolved now, will it save you from going to a parent coordinator for the next 5 or 10 years? Because parent coordinators, they're not free. So you know what I'm saying? So it might be best to just go ahead and go to court. Do a cost benefit analysis all the time, all the time. And when I say cost, I don't necessarily mean monetary. Sometimes it's the cost of, the headaches and the stress of going to court. Some people just don't like going to court, or losing time at work or losing time at home with the kids. So, but do a cost benefit analysis to decide which is best for you. And let me just say this. I love participating in communities and groups where people come in and ask questions and get advice and get personal opinions and insight. But I don't like when people come in and say, "Hey, this is what's going on with me. You guys tell me what to do." That irritates me, because every story, every circumstance, every situation is different. You know what I'm saying? And especially when they come in with a little bit of information. Oh, my ex got arrested last week, and I want to know, what do you guys think? Should I withhold visits this week? No, we don't want. You can't. First of all, you shouldn't be asking a room full of non-professionals that question. Number one. Number two, that's like you're asking people to give you an answer or justify you violating an order. Number two. Number three, we don't know the background of your case. Even me as a professional, I don't know the background of your case. I don't know if there's been other violations before, or if he's been warned before, or she's been warned before. or if this issue has never come up before. All of these things matter. All of these things has an impact on how you should proceed. And I know sometimes people get irritated when they ask me questions and I give them a general answer, but most people who are professionals in this arena, they're going to say, you know what, I don't know enough about your case to give you that answer. I can tell you what the law says. I can tell you what's likely to happen based on your jurisdiction or the laws of your jurisdiction, but that's all I can. I can't give you a definitive answer, and that unnerves me. I mean, again, I love the fact that they come in and ask questions, but when you start to get too, your issues start to get too esoteric, too unique to your situation, expecting a room full of, especially the ones where there's, lay people, expecting a room full of lay people, strangers, to help you make that decision, to me, is not the best approach. And personally, I wouldn't trust those people because some of them are angry and bitter and evil. And so they're going to give you their insight from that perspective. They can't give you anything else from any other perspective because that's where they are. And I'm not judging them, because divorce, custody, all of this can be very, very, it can be very debilitating. It can be so, it breaks people down. I know that. I've been doing this for 18 years. However, you have to understand that a lot of people, even some lawyers, they're going to be very prejudiced, very biased. We're human. We have biases just like everybody else. Judges have biases too. But still, at least we're trained to be a little bit more objective and to not give you some advice or give you an opinion or direct you to do something based on where we are. We know that. We know better than that. So, I digress, which I always do, but I just wanted to make that clear. So, so I want to now go through some of the specific questions that I got from whichever group I was in or whatever community I was in, and help you understand what joint legal custody is and what it is not. And this is a very good one. So someone says, does anyone have any experience with joint legal custody and the parents disagreeing on medical treatment for the children? So her daughter was prescribed the medication, and the father objected to giving the child the medication. And he said it's drugging. He didn't believe in drugging, blah, blah, blah. But the mom was like, listen, I have residential, he doesn't get to see how she suffers when she's not taking the medication. However, they have joint legal custody. This is a typical scenario where joint legal custody comes up. This is where it applies, because there's an issue with whether or not prescribed medication should be given to the child. And so this falls under medical treatment. And yes, both parents never mind that he's not there to see what the child does. It doesn't even matter if he only gets the kids 20% of the time and they're with mom 80% of the time. The fact remains they have joint legal custody, and he has some input and he has some say. Now, how they decide to work that out, that's entirely up to them. Oh, let me just back up. One of the other ways that stalemates can be decided is the parties can include in the parenting agreement that a medical professional gets to decide, can be the final decision maker when it has to do with medical, or a school professional can decide, can be the final decision maker when it comes to education, and so on and so forth. But in this particular scenario, guess what? Yes, dad has a say. Doesn't mean dad is going to prevail. Doesn't mean mom is going to prevail. What it means is, if there's no provision in the parenting agreement that says who should be the final decision maker, if they don't agree, they can use one of those alternatives I mentioned. They can either, seek the assistance of a professional who's that's their role, is to be an objective, third party to help them decide, to help them weigh the options. Even mediation, you can always go to mediation for post custody issues, post divorce issues as well. You can always go to mediation instead of going right to court. You can always go to mediation. Of course, make sure you choose a mediator based on the issues that you have, because you don't want to go to a mediator who has no clue what they're dealing with. Like, you don't want to go to a mediator who is only versed in, you know, I don't know, property issues. Excuse me. I'm not feeling that good all of a sudden. But you can employ the use of a mediator, a parenting coordinator, things like that. And I'm using these terms. It can be whatever they're considered, whatever label they're called where you are. Everyone has someone where you can actually employ the use of a professional, experienced professional who can help you, break a tie or a stalemate or whatever have you. And so in this particular scenario that I just read, I'm assuming that they didn't include that. Who should be the final decision maker? Because she wouldn't be asking this in the group. I'm assuming, because, if she did, she would know either dad or mom is the final decision maker. A lot of times it is the residential parent that has the final say because of some of the concerns she raised. Dad, they're with dad less time than they are with mom. Mom gets to see the kids every day, all day, and mom knows what the repercussions are if the child doesn't take the medication. Dad doesn't, because he doesn't see them that often. So a lot of times, for that reason, the residential parent or the sole custodial parent is usually the one that is the final decision maker or the final tiebreaker, whatever you want to call it. Whatever. Semantics. It's a matter of semantics. But what she was also concerned with is on his weekend. On his weekend, will he administer the medication to the child? That's a very good question. That is very good. And let me tell you, because I see that happen a lot. And a lot of times, that's what actually brings the parties to court, when they realize that, okay, it's like, parallel parenting. You're going to do what you want to do at your house, and I'm going to do what I want to do at my house. And sometimes it works. Sometimes if it's, my son has really, really bad allergies. I am not pro medication. I am not. I am holistic. I believe in alternative medicine for everything. But my son's dad, when we didn't have joint custody, but when he would visit with his dad on the weekends, his dad would load him up with all kinds of allergy medication. And for me, I'm like, oh, I would cringe. But I can't dictate what he did at his house. He knew how I felt. Mommy's doing a live right now, sweetie. Are you feeling bad? I'm sorry. Okay. Okay. Um, he would load him up on allergy medication. I'm sorry about that. My son is still grieving the loss of his dad. So every now and again, he gets a little sad and needs some extra TLC. So I have to give it to him. And he knew how I felt. He knew from the moment he met me that I was more of an alternative medicine person, but he was so opposite. If he had the slightest tinge in his head, he would pop, Excedrin, or whatever. And I'm like, no, I'll ride it out. I'll wait until it gets so excruciating where I can't take it. Or I'll take something that's more natural, or do something that's more natural. So, but you know what? That I couldn't do that. I couldn't micromanage. I couldn't dictate what he did when he was with dad. I couldn't dictate even his diet. So what happens in a situation like that? You have a choice. If it's medication that's critical to her well-being, then you might want to go back to a judge and let the judge order him, or and I'm saying him because I'm talking about the scenario that I just mentioned, and order him to actually administer the medication even when the child or the children are in his care. Okay. Or you could just not do anything, not say anything, and just pick up where you left off when the child or the is back in your custody. That's entirely up to you. Again, you have to do a cost benefit analysis. How serious is it? How important is the ailment? How what's the word? How effective is the medication if it's done consistently, or how ineffective is it if there are days missed? So you have to determine all that. just running to court, I never suggest that to people, because sometimes what happens when you run to court for everything, not only do you, spend money unnecessarily, but you also give the judge an image or impression of you. And I have not met one judge who does not want to see parents co-parent without the court's intervention. I have not met a family court judge who does not advocate parents making decisions amongst themselves. So every time you, especially if you're the one constantly running to court, then guess what? You start to create an image. You give the judge an impression of you. One, that you can't co-parent, or you're cantankerous, like you like fighting. You're the one that's high conflict. And so anything you mention now, your credibility is starting to diminish now, because you're the one constantly filing contempt, modification, whatever. So, and so I'm not an advocate of that. Even when I was in private practice, I was always concerned with the image my clients gave the court. And yeah, it would not make my clients happy that I would say, what? And even I tell people in my audience too, you don't want to run to court all the time. You just don't, because now you're giving, they make impressions. They get impressions of you. Yes, yes, they do. And so sometimes, either bite the bullet, pick your battles, wait until they pile up or whatever, but you can't run to court for everything. If your child is not going to die because she misses 2 days of medication, um, you know what? Talk to the doctor about that and see what the doctor says. Can you double up when the child is back in your home? Is there something else that the dad may be willing to do that meets his standards, or that satisfies his concerns, addresses his concerns? I mean, just think creatively. And I hear people say, "Oh, you don't know my ex. We can't communicate about anything. It's always high conflict. It's always a battle." I do believe that. I do believe that. However, I don't believe that for everybody who says that. I believe the way you actually deliver your message makes a huge difference. And if you know me, you know everything from me is strategy. So I'm strategic with every single thing. Nothing gets by me when it comes to me coming up with a strategy to get what I want. Nothing. I mean, even if I overhear you talking to someone else and I overhear you, guess what? Something you said in there is I'm gonna think about, and I'm gonna incorporate it into my strategic plan, effort, attack, defense, whatever. So I do think that sometimes the way you deliver, or the way you ask, or the way you bring up certain topics to your ex or soon to be ex, that actually creates the automatic standoff, where now they don't want to cooperate, or they don't want to agree or work together or something like that. Not everybody, because I've seen some people who are just, steadfast. They're like, no, but that's not true for everybody who tells me that. So, and not that I think they're lying, I just think that there's a way. There's always a way. Yes, I've had instances where I wasn't successful, but not many. Okay, I want to give you another, maybe two more, because this one was a good one. Let me just find it. I'm scrolling through this one. What was it? Oh, I know what it was, but I want to read it. I want to read it because it'll, oh my God, this is crazy. I have to go through so many. Oh, yeah, I just saw it. Sorry. Okay. Are parents who share legal custody obligated to let the other parent know when their child is home sick from school? What do you think? Do you think something like, oh, my such and such missed school for the last 3 days because they were sick? Do you think the other party, or the other parent, the other joint legal custody parent, needs to know that? A lot of people would say no, because that's more day to day. However, in context, yeah, it might fall under joint legal custody because say the child has missed several days last week or last month for the same thing, or you know, the residential mom or dad is keeping the kid out of school for something bigger than what they're really addressing or something that they're ignoring. That can be, yeah, that can be considered something that falls under joint legal custody. If it's day-to-day stuff, typically day-to-day stuff like, oh, I'm just calling to let you know that Michael made it home late today from practice because blah blah blah. You know, you don't have to call the other parent to discuss that or text or email about that. That's not, you can, no one's gonna, you know, chastise you for doing that, but it doesn't fall under what you're obligated to do under the joint legal custody parameters. However, like I said, with the missing of the school, because it could be something medical, something, some medical condition that's being ignored that the other parent has some say in. Should should Michael go to see a gastroenterologist because he missed 2 days last week, and he missed 3 days the week before, and he missed 10 days last month? Yeah, those school missed days now they become, and not only that, how about educationally? How is that going to affect him making it, you know, out of his grade, being promoted to the next grade, affecting his academics? Yeah, so that's everything in context. You know, if it's, you know, a one-time thing, oh, he missed yesterday because he had a tummy ache, you know, that's not joint legal custody. That's more of a day-to-day. And if you're residential, you're the residential, then that's, you know, you can, again, you can, but it doesn't fall under the parameters of joint legal custody. So, but you know, you have to be mindful of that because some people wouldn't necessarily think that. They'd be like, "Oh, it's just that's not in the sphere." You know, that's something that, you know, I'm residential. He does. I don't need to share that with him or her. Um, but again, yeah, I'm gonna try to find one more. I'm trying to find one more. Ah, this is a good one. So the joint legal custody agreement a lot of times covers extracurricular activities, right? Question is, this is not a, I don't have a hypothetical, but I'm just going to throw some out there. Question is, what's considered an extracurricular activity? Is it something that the child has never expressed interest in, and now all of a sudden they want to try it out? Is it, you know, adding a sixth activity to his already or her already busy schedule? Is it something that both parents would be obligated to transport the kid to and from? Yeah, that's where a lot of the disagreement comes in at, because extracurricular activities, it starts to interfere with scheduling, with logistics, meaning the pick up and drop off, costs, commitment. You know, if it runs into summer vacations and summer visitation schedule, um, all of those things, all of how far they should go in the in you know, in participating in the extracurricular activities. So yeah, that is really really important to actually, you know, delve into more than just including the joint legal custody covers extracurricular activities. No, you have to be specific. You have to be, if that's what your agreement is going to cover, your joint legal agreement, joint legal custody agreement is going to cover, you have to be specific, because I can almost assure you, if you don't, and you or your ex, soon to be ex, has plans to either have the child or children very active or not, you will have issues. You will have a lot of stalemate issues going on. So that's one provision that I suggest that you actually try to be as specific as possible. You don't have to say, exactly what time, but you have to cover the cost, who's going to pay what, which is sometimes covered in child support. But you can if you don't have a child support order, you can include that there. How it's going to go with when the activities fall on the other parents' parenting time, um, who's going to pick up and drop off, who's going to attend special programs and playoffs and stuff like that, et cetera, et cetera. So that's because you will be back in court or dealing with, mediator or parent or whomever you decide, however you decide to employ the use of a third party. You will be using one if you do not try to be almost as explicit and as expressive as possible when you're referring to the extracurricular activities. So that is all I have for joint legal custody today. If you have any questions about that, feel free to post a comment here, or if you're not in either one of my groups, join them. It's Pro Se, Divorce, and Custody, and then it's the Divorce Glow Up, both on Facebook, or you can always DM me. I'm always open to receiving DMs, not excessively though. Please. You can email me at divorcecoachesq@gmail. You can go to my website at www.thedivorcesolutionist, which is scrolling right across the bottom of your screen. You could follow me on Facebook, the Divorce Solutionist on Facebook, on Instagram, and on LinkedIn. It's the same thing, the Divorce Solutionist. But if you have questions, if you have suggestions, feedback, comments, etc., please do not hesitate to reach out to me. I am always accessible and available and welcoming of questions and comments and just chatting it up sometimes. But anyway, I hope this was helpful again to someone out there. Please take advantage of my free 15-minute consultation, which is done by Zoom. So I get to see your pretty face or your handsome face. If you're interested in doing that, you can do that at www.calendly.com/divorcecoachesq/15 minutes. Actually, the link is actually on my page, on all my pages. It's somewhere on all my pages. So until next week, thank you for tuning in. Bye.